Hello everyone. Welcome back. Today we are going to cover our last topic for professional responsibility subject. In lecture 6 we are going to cover topic D, access to justice. In this, the main questions that we are going to cover first is, what do we mean by this term access to justice? Then, what are legal needs? Are there any current access to issue crisis? What does that mean? Who should be responsible for providing this access to justice? What is the role of advocates, lawyer in this thing? Then what is the profession of law? Talks about access to justice. Then what are the options to address this issue? Then how does legal fees, pro bono, paralegals work in this whole scenario? So what is meant by access to justice? I will be explaining you very simply, because if you understand this word, only then you're going to understand the rest of this whole lecture. And this concept, these three words, this phrase is in itself a complete topic. So justice, we all know that something what the court of law do fairness, provides you just decision, right decision. Whenever your rights are getting infringed, the court is there to protect your rights. So we say that okay, justice has been done. Access. Access means entry. So how you reach that justice is access to justice. So access to justice is a basic principle of rule of law. It does not only include here seeking justice, it also include a proper legal representation, because only through a proper lawyer legal representation one can get the justice. Then understanding your legal problem, knowing what to do about it, this also include access to justice. Getting the right help with the legal problem. So if you are taking some advice from a non-legal person, then that does not mean proper access to justice. Proper access to justice means a proper legal knowledgeable person is helping you out with your right. It also includes legal advice from a lawyer, representation from a lawyer, being able to deal with your legal problem and being able to understand the result outcome, making sure your voice is heard. So these all things come under access to justice. So it is a fundamental concept that encompasses various factors affecting an individual's ability to seek and obtain fair treatment, as I just told you. So we have two viewpoints on this. Firstly, Mary Ann Nune told that there are several barriers to access to justice. It is not that simple, including geographical, institutional, racial, class, gender, cultural, economic factors. These barriers can hinder individuals from navigating the legal system effectively. Then Chief Justice Wagner further elaborated the meaning of access to justice, emphasized that it extends beyond affordability. So we study this concept of access to justice when we say that every person has access to justice as per rule of law, no matter that person cannot afford a lawyer or not. So if someone is not financially strong, even then that person has full right to have access to justice. So it encompasses aspects such as being informed of one's right, understanding legal procedure, language, having confidence in the fairness of legal system. He also stressed the importance of representation, inclusivity within legal system, as well as timely resolution of legal system. So as per Chief Justice Wagner, all these things, not only because when we say access to justice, we simply only think that okay, this means representation by lawyer, whether a lawyer can provide free legal services, what is legal aid, what are the pro bono volunteer legal services. So these are the only concepts that comes under access to justice. But no, true access to justice means a person should be aware of their legal rights, how they are going to be represented by the court, who is going to represent them, and what will be the consequences of those legal rights. So this is what true access to justice means. So we know what is access to justice: going before court, represent yourself, Now, what are the legal needs of a person? So, legal needs include so many things. So, legal needs encompass wide range of issues that individuals face in various aspects of their life at different steps, like in their housing. You might have some legal need in your employment, education, health. So, these issues often have legal dimension that require support from some legal services to resolve. Understanding the nature of legal need help identify common patterns of problem across different segments of population. In Canada, access to justice is considered as a basic right of economic citizenship. So this is important. There are concerns that unmet legal needs are becoming a crisis within the justice system. So people are having so many issues in Canada. They have so many unmet, unanswered legal needs that are unresolved just because they don't have access to justice. So national and regional studies such as 2014 survey by Canadian Forum on Civil Justice highlighted number of individual experiences legal problem that they struggle to resolve often without obtaining necessary assistance, leading to undesirable consequences. So traditionally, access to justice problem and issue was only focused on lawyers and redressed through the courts, with reform aimed at ensuring equal access to legal aid community legal center. However, there has been shift towards a broader understanding of legal needs. So access to justice does not only mean that you have access to lawyer, it means addressing, understanding complete legal needs. So leading to reforms that address inadequacies within the code legal aid system, promote plain language, public legal education, enhance alternate dispute resolution. So all these are legal needs that comes under access to justice. So is there a current access to justice crisis? Are we still facing issues in Canada with regard to this access to justice? So issue of access to justice Canada is actually severe, affecting estimated 3.8 million people annually who encounter legal problems, who may be unable to resolve them fairly, effectively, affordably. This problem disproportionately affect marginalized individual, vulnerable individual like indigenous people, refugees, minorities, those with socioeconomic factors like age, disability, employment, education. One striking consequence result of this issue is that there are increasing number of self-represented litigants in both civil criminal cases who often face unsatisfactory outcome as compared to legal representation. So this is obvious thing if you are not from a legal background and due to any of these factors or due to economic issues unable to pay fee, you are representing yourself before the court, then definitely who is a lawyer, who is well versed, who is well experienced in the matter, there are high chances that the lawyer will win the case rather than a person who is representing himself without having any legal knowledge. 2014 National Survey by Canadian Forum on Civil Justice highlighted widespread nature of crisis, with nearly half of adult Canadians experiencing at least one serious, difficult to resolve legal problem within a 3-year period. So there are so many factors because of which we have this access to justice crisis in Canada. Number one, high legal fee, lack of legal aid, affordability. Number two, absence of legal aid. Then perception belief. Few individuals may not recognize their problem as legal. So few individuals doesn't even know that the problem they are facing is legal, is severe, and they need to go before the court. Like in family law cases, a person might think that okay, the way I am thinking, I am going to represent myself on my own before the court of law, this is going to work. But no, a person who is lawyer, who is representing the other party, your opposing party, you have to take that thing very seriously so that it won't affect your case. But this is the issue. Everyone cannot afford legal representation, so people do suffer because of this. So some individual may not recognize their problem as legal in nature or may believe that they can seek legal advice from a non-legal source. So there's also prevalent belief in self-representation. particularly in family law cases. Then the justice system is so intricate, so complex, so confusing. Spatial geographical barrier. Residents of rural remote regions face these kind of additional challenges. They have limited availability of legal services in their area. Then limited awareness of legal right and resources. These are also the factors that lead to underutilization of legal services. So these are the main reasons why we have access to justice crisis in Canada. So the question is, in furtherance to this crisis, we know that people do face affordable legal representation. Who should be responsible for providing access to justice? What is the role of lawyers or legal profession in this? So talking about Canada, issue involve various stakeholders due to constitutional distribution of power among federal, provincial, territorial government as well as involvement of lawyers and provincial law societies who have their own rules. So understanding who bears the main responsibility requires the consideration of constitutional principles and relevant legal cases. So in the case of British Columbia Attorney General versus Christie, Supreme Court of Canada ruled that there is no constitutional right to counsel in court proceeding. Legislature have the power to impose condition on accessing court. So legislatures can impose conditions on accessing court, but there is no general constitutional right mentioned in Canadian Constitution that person has a right to counsel, because there is a concept of self-representation as well. Similarly, in Trial Lawyer Association of BC versus BC Attorney General, it was held that while provinces have jurisdiction to levy court hearing fees, such fees cannot deny people access to court as it infringe on the court jurisdiction of Superior Court. Then regarding legal aid R versus Moody, important case, court may intervene to provide state-funded counsel if an accused individual cannot afford legal representation, ensuring access to justice. The question of who should pay for legal services raise broader issues. While clients typically pay for legal services, there's recognition that access to justice is a societal concern. So for this, we have to go to Rule 4.1, which makes it compulsory mandatory for lawyers to provide services efficiently, properly, conveniently, and lawyers are encouraged. This thing is not mandatory, only providing efficient and convenient services are mandatory for a lawyer as per Rule 4.1. Pro bono services or legal aid or reduced fees for those people who are in need of it is encouraged, suggested, expected from a lawyer. So some argue that lawyers as agents of legal system should have obligation to ensure access to justice given their monopoly, because they are the only people who can provide legal services and the public interest mandate of law society. But again, this thing is not mandatory. Providing pro bono service, voluntary free legal service is not mandatory for a lawyer, but it is generally expected as per Rule 4.1 of Model Code, that if someone is in need, a lawyer will be there to help him or her out. So those people who advocate ask lawyers to play a more active role in ensuring access to justice argue that lawyers have a responsibility to serve public interest and that legal profession's monopoly on providing legal service create a special responsibility that is almost similar to creating a trusteeship. So additionally, lack of full competition in legal service market may lead to unjustified high fees. So further, this high fees thing is restricting the access to justice. So it is lawyers' duty somehow and legal professionals to come before people and have an active role in addressing this fundamental societal issue. Then what are some concrete options for addressing issues of access to justice? So talking about Canada, efforts have been made to improve this access to justice thing, as evidenced, as seen by the establishment of Action Committee on Access to Justice in Civil and Family Matter by Chief Justice of Supreme Court of Canada. So I have talked about this Action Committee in detail towards the end of this lecture, sorry. The committee's roadmap for change outlined various reform objectives to address everyday legal problems like widening the focus of justice system beyond court, like dispute resolution methods, then promotion of education and prevention, recognizing addressing barriers to access to justice. Then few important highlights from these roadmap include refocusing justice system to a more accessible justice services like early resolution service sector, then making essential legal services available to everyone by modernizing and expanding the legal service sector. Promote access to justice in law school curriculum, in syllabus and in continuing education program. Make courts and tribunal fully accessible. Multi-service center should be there for public dispute resolution. However, some criticism have been raised regarding generic nature of solution proposed, which may not be adequately address the specific needs of marginalized people. So some say that these suggestions by the action committee are very generic in nature. These are not going to curb the root cause where we are talking about the vulnerable marginalized people. To further address access to justice, various innovations have been designed. So legal aid, we all are aware of this thing. There are few legal aid societies that provide free legal services, help people in need, to economically disadvantaged individuals who face serious complex criminal charges. Then we have community clinics. These also offer free or even low cost legal services like for issues, social assistance, housing, employment law. Then we have insurance prepaid legal regime, providing coverage for legal service through prepaid legal services, or we have few insurance packages for legal protection. Contingency fee. These fees allow individuals to pursue civil rights cases without upfront cost by paying legal fees only upon successful resolution. If a case has been solved successfully, if the client who has gone for some lawyers representation assistance have hired some lawyer for the case, then if the lawyer wins the case, only then the person has to pay the fee. So this is in few civil cases, we call it contingency fee. Then class action. If more than one people, larger group of people are involved with similar case, then in order to reduce the fee, we have to allow representative plaintiffs to bring lawsuit on behalf of whole group. So one person can represent the whole group, promoting judicial economy and access to justice. So these are few important innovations that have been designed for this access to justice. Then in Western Canadian Shopping Centre Incorporation versus Dutton 2001 case, Supreme Court of Canada held that class proceeding, which we talked about here, class action, are intended to further three goals: judicial economy, access to justice, behavior modification. So these goals are meant to inform judicial decision making. So class proceeding, a larger representation, is a good way of access to justice. So according to Matthew Good, in Access to Justice, Judicial Economy and Behavioral Modification, exploring the goals of Canadian class action access to justice has been described as most important objective of class proceeding legislation. Then it is, however, a concept defined by economic consideration, because here we are again and again talking about money, that people who don't have enough money. So for those people we have this access to justice concept, for those we have pro bono, legal aid and things like that. So these measures aim to reduce barrier to accessing legal services, promote a fair and accessible justice system for all Canadians. Now, when it comes to legal fees, pro bono and paralegals, the affordability of legal fees is indeed a significant barrier to accessing justice in Canada, because it is affecting low income household and middle income households. The legal fees thing, this is the main barrier. The high cost of legal services has led to situation where individuals either cannot afford legal representation or choose to represent themselves due to financial constraint. So issue is particularly acute in family law cases where majority of litigants appear in court without a lawyer. Then efforts to address the affordability gap has included suggestions for lawyers to offer pro bono services. Pro bono means volunteer free services. Some advocating for compulsory pro bono requirements similar to those implemented in US jurisdictions. So some say that like US jurisdictions we have compulsory pro bono requirements. Here in Canada also we have to bring this. Others have proposed incentive like making expenses incurred during pro bono tax deductible, so that at least lawyers should have something for the motivation. Encourage practitioners to provide free legal service. Then we have few organizations like Access Pro Bono Society of British Columbia. This has played a very important role in providing free legal services to those with limited means by bringing together legal professionals, few students willing to volunteer their time. Additionally, introduction of paralegals, notaries to provide limited, inexpensive, lesser cost legal services has also aimed to address this issue. In Ontario, the Access to Justice Act 2006 makes it mandatory training, liability insurance, and oversight by Law Society to ensure paralegals meet minimum competency standard, adhere to code of conduct that is almost similar to law. So paralegals in Ontario can represent clients in small claim court, administrative tribunal, and they offer affordable alternative to traditional legal representation. So this paralegal profession is a good approach for this access to justice concept. So then we have one of the most important case that you have to 100% mention in examination if you're getting a question on access to justice. So usually access to justice question comes in shorter form, but you never know. Every time NCA examination is a surprise. So you have to prepare this whole lecture, this whole topic as one, so that in examination if you're getting a larger, bigger question on this, then also you will be easily able to write it. You can add on the works that I will be talking about and these kind of important cases. So British Columbia Attorney General versus Christie 2007 case. BC imposed 7% tax on purchase price of legal service, supposedly to fund legal aid in the province. So whenever a person is purchasing legal services, the price, the taxation was increased by 7%. So this was imposed, 7% tax was imposed. Collected tax was included in general revenue, which made it difficult to discern and how exactly know what the money was being used for. So Christie, a litigation lawyer, challenged the constitutional validity of this tax since it would make it impossible for some low income client to retain him. So most of the clientele were low income. He charged very low rate. Many of the fees owed to him were still unpaid. Chambers judge held the tax did breach fundamental constitutional right to access of justice for low income people, declared it unconstitutional. Court of Appeal also upheld this decision. So issue was tax unconstitutional given it denied low income individuals the right to access to justice. Here Supreme Court said the tax is constitutional, is valid. The text of Canadian Constitution, when you go by the wording of Canadian Constitution, jurisprudence and rule of law from a historical comprehension standpoint do not support the conclusion that there is a general constitutional right to counsel in proceeding before court and tribunal dealing with right and people. Respondent has not shown the Canadian Constitution mandate this particular form. So they say, how can you say something is unconstitutional when it is not mentioned in the Constitution? They say, the court say there is no way written that it is the fundamental general constitutional right to counsel in proceeding. You can go before the court on your own as well. So in order for Christie to succeed, he would have had to prove that Constitution mandates this. At para 13, court stated that general right to be represented by a lawyer in court or tribunal proceeding where legal rights or obligation are at stake is a broad right. This is not a constitutional right. Legislature has power to pass any such law. The right to access the court is not absolute. Rule of law embraces three principles. Law is supreme over official of government as well as private individual. Require creation and maintenance of actual order of positive law. Relationship between state and individual be regulated by law. General access to legal service is not currently recognized as aspect of rule of law. So rule of law include other things, many other things, like no one is above law. Government has to enact positive laws for the general good. So it is nowhere mentioned as of now that it is the rule of law that there is a general access to legal services that is mandatory. At para 21, it is clear from a review of these principles that general access to legal service is not currently recognized aspect of rule of law. Christie could have worked legal aid cases or provided pro bono services as an alternative. What is the access to justice issue here? So they say that if Christie feels that some client cannot pay fee, can go for legal aid cases or can provide pro bono services, how can you say that such a thing is stopping someone to come before the court? How is this the access to justice issue? So here problem was there are individuals in society who need a lawyer to exercise, protect their legal right but cannot afford one. So average income of Canadians versus hourly rate charged by lawyer is huge financial difference. Christie case affirmed lawyers are a vital conduit through which citizens access justice and the law. They help maintain the rule of law by working to ensure that unlawful private, unlawful state action is particular do not go unaddressed. So access to justice means different things to different people. It represents only the formal ability to appeal in court. Broadly speaking, it engages the wider social context as well. So access to justice does not only mean your appearance before the court, it has many other things. It highlights if someone is not able to go before the court, it highlights our whole systematic barriers, social context of people. So most confined notion of access to justice encompass the right to have your day in court. So this was mentioned in this work. The notion of access to justice focus on impoverished individuals who are not financially well off to go before a court and have their right protected. So recently legal aid movement has been expanded to include access to justice for middle class. This is the current position of Canadian Bar Association's National Access to Justice Committee. So Canadian Bar Association's National Access to Justice Committee explains access to justice as ability of low and middle class families. So these both categories are involved to get legal help or information they need. So this was as per this magazine. Now how we are going to solve this problem? So solving the access to justice problem, there is a work by Brent Cotter on this, thoughts on coordinated approach to access to justice in Canada. Access to justice, members of our society would have appropriate access to civil family justice if they had the knowledge, resource, services to deal effectively with these matters. So there is a wide, varying range of needs of our citizen when it comes to access of justice. Access to justice does not only mean going before court of law, it also includes knowing what your case is. So access to justice also means access to knowledge, legal knowledge, resources, services that a lawyer provides as needed to everything that is required for an individual case. So as per particular circumstances. So five assumptions or presumptions on access to justice, like where we need access to justice. So access to justice is fundamentally important to how citizens live their life in a respectful society governed by law. Lack of access to justice undermines our society. It undermines the confidence in its fairness and justness. Ensuring access to justice gets harder every day. It is becoming difficult every day. Every single one of us has a responsibility to contribute to solutions. Those of us associated with law have been given an opportunity, have an obligation to preserve, strengthen access to justice. Then how we can do this? So as per these five presumption related to access to justice, meaning there are four important solutions, suggestions in which we can make this thing easier. Court processes could be made simplified so that if a person cannot afford a lawyer, that person is having basic knowledge like education and can understand his or her right, that person will be able to go before the court to present case. Then we have to be more open to dispute resolution processes, the alternate dispute resolution method like simple counseling, then we have simple negotiation, mediation, arbitration. So those are more focused on addressing interest of the parties, like coming to a common solution by a neutral third party. It is less expensive as well. Judges need to be mindful in ordering that certain parties receive government funded representation, where it is highly likely that these directives will be funded out of government sources. Then reconsider the role of the judge in certain proceedings involving unrepresented litigant. Access to justice is a key trait of rule of law, cornerstone of people's confidence in fair and just society. Greater financial support is necessary to facilitate this for citizens. Government should make genuine pledge. Government should make proper crafted, tailored laws that can make procedures simple, understandable, and also that can go for access to justice. We should have more such policies. Government should create policy screens for these kind of things. Then where citizens are in a situation in which they have little or no access to law to advance their right, their confidence in a just society based on law will be eroded. So one should not feel that okay, if I am poor, I cannot have my rights protected. If you are saying every person in every other thing, in every fundamental right, you are saying that everyone has right to this, everyone has right to this, then it is in a way government's duty to enact such law, to focus on such thing that everyone get represented. So what government can do? No constitutional obligation on government. Canadian jurisdictions have attempted to close the gap between cost of legal services and inability of many individuals to pay for them. Consider whether you believe there should be constitutional duty to ensure access to justice. So this you have to ask yourself. Then what lawyers and legal profession can do to solve this issue. So legal aid already attempts to reduce access to justice problem, but there are still few gaps that are left. Legal aid societies we have almost in every law society. These only serve individuals with very limited financial sources, so leaving many individuals without financial assistance. As per Legal Aid website, Legal Aid Ontario raised the eligibility threshold. So they have increased the eligibility to apply for this legal aid free legal service by 6% for its certificate program and clinic law services. Certificate program provide eligible Ontarians with publicly funded legal certification. The financial threshold for a single applicant without dependent is increasing from current $17,731 to 18,000 something. So lawyers are either reluctant to do legal aid due to low pay, or if they do, they must choose whether to do a less than job complete job or provide necessary services at their own time and expense. So sometimes due to this lower pay, it is becoming very difficult for lawyers also to leave their current job or current client and go for someone who has been asked to provide legal aid by that lawyer. And here lawyer have to see whether they want to use their 100% time and expense. Then if they do so, they also sometimes don't give 100% in their services. Now we are going to discuss about few important works which talk about different views on this access to justice concept. First is the work of Richard Devlin, Breach of Contract, the New Economy, Access to Justice. So in this he considered whether lawyers should be obligated, whether it should made mandatory compulsory for lawyer to perform pro bono volunteer free of cost work. So primary right-based arguments suggest there is unmet right to legal assistance, that contractually the legal profession is obliged to respond to the need because of its privileged monopoly situation. So some people, the right-based people who only think about individual rights, primary rights, they say that it is a right of every individual to have legal assistance, and it is only advocates, it is only through lawyers that this legal assistance can be given. So this unmet right has to be indirectly be performed by lawyers. So even if someone is not capable of giving any legal fees to lawyer, it is lawyer's duty to give legal assistance to that person. So this is one view. But utilitarian people argues that one should move beyond the scope of one's own interest, take into account the interest of other people, are dependent on distributive benefit, instrumental consequences of mandatory pro bono. So, utilitarian people, what does this mean? This term means those people who think for the maximum happiness, maximum good. So, utilitarian people who support this kind of view. The second view, these kind of people believe that whatever they are going to do, the consequences should result into maximum benefit. So here they are saying that we are only the primary right based argument only talk about the people who are seeking for legal assistance. So here we are ignoring lawyers' interest. So if we are going to make everything mandatory for lawyer, then where are the interest of lawyer? So they say that everything has to be balanced in a distributive manner. So this thing mandatory pro bono is against the viewpoint of utilitarian people. So now we will talk about both these people and their views in detail. So right-based advocates say that contract whereby citizenry agrees to leave the state of nature in pursuit of mutual interest, contract between citizen and sovereign means government, whereby government agrees to protect the rights of citizen and enforce the rule of law. So they say that there is an indirect form of contract between citizen of a nation and the sovereign authority, the government. So it's government's responsibility to provide every right to them. So even if citizens are seeking for right to legal assistance, the government has to provide them. So here, in order to provide this particular right, who can give it? Only the people who are related to legal profession can give it. So practice of law in Canada is a state created and facilitated by privilege and advantage. There is no different rule of professional conduct that require lawyer to provide legal service to those of lesser means just aspirational proposition. Lawyers have proactively encouraged the monopoly they have over the legal system. So they say that lawyers have a kind of complete control over this legal system, as they have resisted paralegals, other non-lawyer agents who could provide access to justice as a lower cost. So they say that usually we see that paralegals are not everywhere, they are only in Ontario state. So lawyers have themselves discouraged other people to enter into this legal system so that paralegals or other non-lawyer agents, by performing the lawyer's duties at lower cost, could not provide access to justice. So these people say that it is the lawyer's duty. If they want monopoly, their only single control in this legal system, then it's their duty to provide legal assistance. Utilitarian people say that the benefit should be distributive, promoting more just outcomes, enabling more individuals to enforce entitlement to crucial benefit, enhance legitimacy, what is right, increasing public regard for lawyer, expand attorneys' awareness of how law function for subordinate people, instrumental values for individual institution for pro bono work, that is project a positive public image, boost morale, improve quality of life, create network social capital. So they said rather than making it mandatory, do actions that are for the benefit of whole society, not just one category of people. So there are arguments against mandatory pro bono, mandatory free volunteer services by lawyer. So first one is autonomy. Lawyers have themselves right to, as I told you earlier with regard to utilitarian point of view, and should not be conscripted to provide services without remuneration. How lawyers are going to feed their own family if they will be compelled to work for someone not of their choice, infringing their own right to self determination? You cannot force anything upon a lawyer. Then economics of law practice make demand for pro bono unrealistic, especially for the smaller law firm. They have to pay to the lawyers as their employees. So this is the necessity, this is the requirement, this monetary thing. Unfairness. You are doing unfair thing with lawyers. Then competence. As a result of specialization, some lawyer may have little they can offer to disempowered. Then pro bono obligations are not efficient way of realizing benefit of broadband access. So lawyers who lack expertise to serve underrepresented group will not provide cost-effective representation. So this is also going to affect the client case as well. Then mandatory pro bono is an oxymoron. Essence of pro bono, it's voluntary quality. When the meaning itself means volunteer, how can you make that thing mandatory? So this is inherently in itself contradictory. Number of lawyers who do not fit within either the monopoly analysis or public asset theory, like in-house counsel, then we have government lawyer, law professors, they are not providing direct legal services. So how they are going to make anything mandatory from them? So this is not going to fit in this today's modern world legal profession. Then Alice Boule, another important scholar, he has different views. Let's see. Imperfect duty, lawyer's obligation to foster access to justice. So Woolley rejects almost all the contentions that we read previously given by Devlin in his work because they do not offer a sufficiently accurate portrait of lawyer's role. So there we saw that Devlin has just told us what right-based advocates say, what utilitarian-based advocates say. There he lacked. So that was one of the criticism, also a loophole drawback of his work, that he lacked to portray the real accurate role of legal lawyer in a legal system. Woole argues that there are conceptual justification for the imposition of special obligation on lawyer to promote access to justice. He says we can promote access to justice and there are different ways in which we can do so. An economic market must have 5 central attributes. So if you want to create an economic market, what are the things that it should have? Number one, different number of buyer and seller. Product should be same. Complete information, free entry and exit, nothing mandatory, nothing forceful, absence of any external force to enter into that market. With exception to the first attribute, this numerous buyer and seller, the market for legal service satisfy none of these. So he says that you cannot make legal service an economic market. You cannot attach this monetary thing to this because here we have numerous buyer and seller, but all other 4 points that make it a economic market, that are missing. So legal service market is characterized by relative absolute informational insufficiency. Two economic consequences likely to arise from market of legal service. So from market of legal services, what are the things that can come up? So number one, if there will be imperfection, then that will result to diminuate the quality of legal service. Then imperfection will lead to price escalation. And few lawyers, high priced lawyers are likely to be viewed as high quality. So if we are going to add on these kind of economic concept to legal service market, then it would be very unjustified, unreasonable. So imperfections in the market for legal service provide opportunity for lawyer to obtain economic windfall over compensation because few will be seen as high quality. So here lawyer has to provide access to justice, but that does not mean he has to do his duty imperfectly. So this is what Alice Boole tried to say. So then we have an action committee on access to justice in civil and family matters. So National Action Committee is there. It is focused on fostering engagement. Then leadership of the former Chief Justice of Canada, Beverly McLachlan, to raise issues relating to improving access to justice for all Canadians has done much to focus the attention, energy. So he was the main leader for this action committee. Action committee has emerged as a voice for system-wide improvement that at various steps, especially in civil and family matters, we need access to justice facility at various steps. So action committee is focused on fostering engagement, pursuing a strategic approach, how we can bring civil justice with combined efforts. So Model Code 4.1 rule says a lawyer must make legal services available to public efficiently, conveniently. Subject to Rule 4.12 may offer legal service to a prospective client by any means. So this is important to note. In order to uphold this particular rule, Action Committee has started working. So as a matter of access to justice, Commentary 2 says, it is in keeping with best tradition of legal profession to provide services pro bono, to reduce or waive a fee when there is hardship or poverty. So these are the conditions for access to justice that are highlighted under this Commentary 2 of Rule 4.1. Law Society encourage lawyer to provide public interest legal service support organization that provide services to person of limited means. So if there is an organization that is working for people who cannot afford to pay fees to a lawyer or to who cannot have access to legal assistance, so it is always encouraged, always expected from lawyers by law society that this is a part of your professional conduct, your ethical moral conduct. You have to provide public interest legal services and you have to support those organizations from time and again. So what are the initiatives to foster access to justice? So in order to have this, Canadian law societies have traditionally accepted that lawyers have a special obligation to foster access to justice. No Canadian law society, however, has taken any positive step which can make it mandatory for the lawyers to provide access to justice. So access to justice means every person should have access to court of law if that person's right has been infringed. Access means you are going to court of law. So how can you go? Only through a lawyer, only through legal representation. So this is what simply access to justice topic means. So in this, we have studied that lawyers are the main person who can help people. Because at the end, who is going to represent you? A lawyer. So if you are not able to pay a fees, if you are poor, then it's lawyer's moral ethical duty to help you out. But again, there is nothing mandatory. It's 100% up to a lawyer if that particular lawyer wants to go for access to justice, want to help you in legal assistance for free or for lesser fee or can waive fees, whatever. So that is up to a lawyer. So at last we have to go through an important work by Mary Abbott's Viewpoint Pro Bono Publico for the Public Good. So monopoly that lawyers claim to have over this profession has been eroded. Abbott's believe that erosion is due to initiative of those very government who tell us what we should do pro bono work in order to protect it. So by engaging in legal aid pro bono work, lawyers are not just serving individual citizens, they are also contributing to the legal system, to democracy. So this is democratic work. So this is true meaning of public good. So in examination, if you get question on meaning or basic concept of access to justice, you can refer to Mary Abbott's case and tell that in this case, Mary has beautifully told us the meaning of access to justice. So this is the work for public good, not just for goodwill of member of public. So issue is that a sort of legal food bank. This has become a legal food bank. She goes on to explain that pro bono service alleviate hunger for some on a daily or monthly basis, but then it absorbs the energy of alleviators so that they have little left for changing the underlying condition that create hunger in the first place. So this is kind of continuous thing that keep on coming from where it left its position. In other words, we are fixing only the surface issues. We are fixing symptoms of a problem but not going to the root to actually rectify the cause of problem. So she says that it's okay, a lawyer can provide pro bono service. So the hunger of people who need this service can be curbed on a daily basis, monthly basis, but in return, what we are taking? We are taking the energy of elevators. So we have to go to the root cause, that why this is happening, why we need access to justice, why aren't there any proper rules for this? Why are we wholly dependent upon lawyers for this? So this is the thing that Mary Abbott has beautifully highlighted in her work. So again, you can use her work to tell the true meaning, true purpose, scope of access to justice, and then you can say that we have to go to the root cause if you get a question on whether this issue has been curbed completely or no. So then you can mention this last passage as well. And you can paraphrase it, refer her name, refer the title, and you can write it in examination. So that was all for today. With this, we have covered all theoretical topics. Last lecture will be our answer writing session. So you have to send me your written answers. Then I will be reviewing that, giving you feedback, as well as we will be discussing the latest sample paper in that final answer writing session. So thank you and good luck.